Yes, it is the appointed time and we have a quorum. The quorum is 3 members and we have got 3. This is the Subcommittee on Construction Workers Registration Exemption Regulation and Construction Workers Registration Ordinance, Amendment of Schedules 1 and 1A Notice 2016. We need to elect a chairman. According to Article 22 and Schedule 4 of the House Rules, we would like to have a nomination. It should be made orally by 1 member and to be seconded at least by another member orally, and it should be accepted by the member so nominated. Mr. Jonathan Ho, I nominate you, Dr. Loy Kwok. Any seconder? Thank you. I accept nomination. Procedurally, I have been nominated and I accept nominated, but then in fact we should have the most senior member in the president's list to chair the election of chairman. In fact, Mr. Jonathan Ho, you should come here and take the chair so that you can chair the election of chairman procedure. We don't have any choice. We have to follow the procedures. Any other nomination? No. I declare Mr. Loy Kwok elected chairman of the Subcommittee on Construction Workers Registration Exemption Regulation and Construction Workers Registration Ordinance Amendment of Schedules 1 and 1A Notice 2016 ipso facto. Mr. Low, please take the chair. The 3 of us are really hardworking. I don't think we need a deputy chairman. I think you agree with that. Shall we now proceed to the meeting proper? Let us invite the administration team to come in. Let's welcome officials attending this meeting. You have the attendance list, so I won't read out the names. Shall we now ask the administration to introduce the subsidiary legislation to members? And then the floor would be open to questions. Who would be taking us through the registration? Mr. Vincent Mack, DS, Chairman. We have proposed the subsidiary legislation to Legislative Council for negative vetting. The first one is the Construction Workers Registration Exemption Regulation, and the second one, Construction Workers Registration Ordinance Amendment of Schedules 1 and 1A Notice 2016. As we stated in the Legislative Council brief, in order to implement the Construction Workers Registration Ordinance and also the Designated Workers for Designated Skills requirement, we have already had the ordinance amended and supported by Legislative Council in 2014, and it came into effect in 2015 January, and we would be implementing the DWDS requirement in phases, and on the 1st of April next year, we would be regulating the larger scale construction works, and then later on we would regulate other small scale works so that people can adapt to it gradually. And then after that, we would have to do 2 things as follow up. Number 1, according to the new Section 63A, the Bureau of Development will have to come up with an exemption. And then secondly, there will be the adding of 3 trades into the regulation, namely false ceiling installer, partition metal frame installer, and cable jointer dead cable. About the exemption regulation, the purpose is to exempt designated works and workers, so they would not be under the DWDS requirement in order to reflect the actual situation in the trade. And the exemption would cover 3 areas. 1, emergency construction work. And the exemption has the purpose of allowing contractors to take immediate action when human lives are to be saved, and this will be in the public interest. In formulating this exemption, we have already given consideration to trade practices and also safety and quality of works. Because of consideration for the safety of workers and the public, this will only apply to 47 trades out of the 142. The other kinds of skill work cannot be exempted even during an emergency. And also, the well-established takeover procedures will help us make sure that the quality of works will not suffer as a result. The second exemption is for small-scale construction work. According to construction trade practices, some small-scale construction work involves different trades, but then the level of skill required is relatively low. Usually this is carried out by registered general workers who may not possess the full skill set in order to be fully registered or semi-registered. Allowing general workers to continue their work, the Exemption Regulation exempts certain small-scale construction work from the DWDS requirement. In formulating the works to be exempted, we have given detailed consideration to the practices of the trade and also the safety of workers and the public. The third exemption is for persons already exempted under other specified ordinances. The purpose is not to affect exemptions under the gas safety registration of gas installers and gas contractors regulations, the electricity ordinance, and the lifts and escalators ordinance, so the relevant workers can continue to undertake works exempted under these ordinances. In 2010 to 2013, we were formulating the ordinance and we already came up with the details for such exemption. We also had a very extensive consultation with stakeholders. We have had 100 meetings, including 5 consultation sessions with the public. At the beginning of the year, when we decided on this exemption, we again consulted the industry and also the Construction Workers Registration Board and other stakeholders, including trade unions and chambers of commerce. They all supported the proposal. As to the addition of 3 trade divisions, actually in 2014, when we formulated the amendment ordinance, the industry already asked the CIC to do this. But at that time, there was not enough time to forge a consensus. Therefore, last time when we enacted the amendment ordinance, we did not add these 3 trade divisions. The CIC has had very detailed consideration of this, and they have now forged a consensus. And in May this year, the CIC wrote to the Development Bureau to have the ordinance amended in order to add these 3 trade divisions. On the 8th of November, we introduced the 2 pieces of legislation, subsidiary legislation, to members, and members did not object. After that meeting, we issued supplementary information to members in order to provide information to members on areas of concern. That is my introduction, Chairman. Thank you. Any questions? Mr. Yu Chong-yim. Thank you, Chairman. I have a few simple questions, please. Number 1, in the subsidiary legislation, do you have any provision for a review after a certain time of implementation, say whether people can adapt to the new changes and whether improvements are required? Secondly, I can see that This time around, it is different from previous practice, and that is for the CIC to decide what kind of training will comply with the regulations. In the past, it would be up to the Vocational Training Council to decide, but this time around, you have left it to the CIC. I'd like to know whether there is a change and what is the impact, if any. And number 3, in terms of the 3 trade divisions, for example, false ceiling installer, will there be a definition in the regulation? Because the industry may not have defined false ceiling, for example, in detail. Do you have a definition of such trade divisions? Right, 3 questions. I'll try to answer the first question first. Any review after a certain period of time. As I said, in setting the DWDS requirement, we have done so in a gradual manner. So the entire industry will not be affected by the making of this requirement. Of course, after a certain period of time of implementation, we will take a look at the situation and seek the feedback of the industry on the requirement in order to decide whether there should be an addition or deletion of requirements under the ordinance. This is done from time to time. But is this provided for in the ordinance? Do you have a review time frame?
This time round, we didn't specify the time frame for the review. As I said, the review will be an ongoing process. The CIC is in continuous operation. In fact, several years ago, the ordinance already commenced operation. The first phase has commenced operation, and we're now in the second stage on DWDS. And so within the sector, there's been ongoing dialogue all the time. So we don't think there is a need for us to specify how or when review will be done. I think you are doing this based on the actual situation and the needs of the sector. I'd believe that you will also be adding in new trade divisions as well, and you will do a review from time to time. I suggest that you consider building into the ordinance a regular review mechanism. It's better or preferable than having people initiating it on their own. Well, as for the qualifications, can I defer to Mr. Chow to elaborate? Thank you. With regard to training and also the test certificates, this falls under the work of the CIC. You mentioned about the Vocational Training Council. Now, if we talk about electric fitters and water plumbing workers, then they will be under the VTC. But then if we talk about construction workers, they fall within the portfolio of the CIC, which is promoting the training of the skilled worker in these trades. So that's been the established practice all along. Now, with regard to item 13, the craft or the craft worker, the lifting worker. Now, all the certificates will be issued by the CIC, but then, well, the Construction Industry Council was the predecessor of the CIC. And after the CIC was established in 2007, it had taken over the work of the former body. So it's been continuing with its work. It's the same organization. The CIC has taken over the training of these workers. Why don't you make the change at one go? Well, this has been handled or dealt with under the CIC ordinance. The training programs used to be undertaken by the Industry Training Authority had already been taken over by the CIC. That's specified in the relevant ordinance. Now, for the false ceiling installer, if you look at the Schedule 1 and also Notice 1A, Part 2, Schedule 1, it says clearly that it is there to install the false ceiling. We have discussed at length with the relevant trade unions. We found that this description is already clear enough. And if needed, the CIC can issue further guidelines with more detailed descriptions. But for the description as outlined in the legislation, that's already been agreed upon by the trade, and they agreed to that description. Any other question? If we don't have any further questions on the introduction just now, then I think we can go to the clause-by-clause scrutiny. And maybe you can ask further questions during this process. Shall we look at the exemption regulation first? I believe that you have the paper with you. So let me try to explain the regulation. Part 1 is the preliminary. Clause 1 is the commencement date. Subsection 1 and 2 says that the regulation comes into operation on the day on which Section 3, bracket 2 of the Construction Workers Registration Ordinance comes into operation. And Section 3.2 has to do with the requirement on DWDS. In other words, this regulation will commence on the same day as the DWDS takes effect, that is the 1st of April next year. Now, with regard to items 25 and 31 of Schedule 1, that is on the false ceiling installer, and also items 14 and 18 of Schedule 3, that is on the partition metal frame installer, come into operation on the expiry of 24 months beginning on the day on which Section 3.2 of the CWRO comes into operation. So these fall on the same day as the DWDS. Well, because these are newly added trade divisions, so it takes they will take effect after 24 months after the CWRAO commences operation. Interpretation. In this regulation, required skills in relation to a designated trade division means the skills described in column 3 of Schedule 1 to the ordinance opposite the trade division. All right, that's also clear. Section 3 is interpretation of Part 2. In this part, the definition of controller, emergency work, material, time are outlined. Controller in relation to a construction site means the principal contractor for the site, or if there is no principal contractor for the site, a person who has control over or is in charge of the site and is in line with Section 58, bracket 9. And emergency work means any construction work reasonably required to be carried out for saving human life, preventing personal injury, preventing damage to property, preventing serious interruption or disruption to a public transport system or utility service. So such work will be reasonably required to be carried out immediately. So that is in line with the definition of under Section 28 of the Land Miscellaneous Provisions Ordinance. And also material time in relation to any emergency work on a construction site means the earliest time at which a controller of the construction site becomes aware of the emergency due to which the work is required. So we have to cross-reference with the Land Miscellaneous Provisions Ordinance, is that right? No, the emergency work has already been detailed in this regulation, or we are saying that we have made reference to that other ordinance in coming up with the definition in this regulation. So they are consistent, right? Yes. All right, Section 4, and that is on exemption for emergency work. Subsection 1. This section applies to any emergency work that A. involves any required skills of a designated trade division specified in column 2 of Schedule 1. Schedule 1 requires skills, and its B is carried out on a construction site within 72 hours immediately after the material time. Subsection 2. To the extent of the involvement of the Schedule 1 required skills in carrying out the emergency work, A. The emergency work is exempted from sections 3.2, 3A4, and 48.1b of the ordinance. All right, any further views? 5. Duty to notify and submit record. 1 and 2, subsections 1 and 2, specify that if any emergency works is carried out on a construction site within 48 hours immediately after the material time, and controller of the construction site must within that period notify the council of the time at which the emergency work commences, so that the council can carry out inspection and enforcement work. And subsections 3 and 4 specify that a controller of construction site on which any emergency work specified in Section 4.1 is carried out must within 96 hours immediately after the material time submit to the council a record of the emergency work. And subsection 5, a person who without reasonable excuse contravenes subsection 1 or 3 commits an offence and is liable on conviction to a fine at level 3. Well, if you just say council, will it be confusing? So far, it hasn't mentioned anything about the construction industry council. Well, maybe it's in the principal legislation, but should we be clearer here in the drafting? Yes, let me take that question. You are right in pointing out that in the principal legislation there has already been a definition for the council, and according to the general clauses and interpretation ordinance cap 1, there is already a provision there. So that's already been referred to in the principal legislation, as pointed out by the legal advisor. So there's no problem here. Okay, please continue. Part 3. Is about exemption for small-scale construction work. And this covers only 47 trade divisions in Schedule 1 only. There are 3 types of small-scale construction works exempted. One is the specified small-scale construction work, and also small-scale construction work involving certain designated trade divisions, and also exemption for small-value construction work. They are set out respectively in Section 6, 7, and 8 of the regulation. Section 6. Exemption for specified small-scale construction. There are 13 types of works altogether, and these are set out in Schedule 2. And subsection 1 specifies that subsection 2 applies to any construction work described in column 2 of Schedule 2, that is carried out on a construction site. And subsections 3 and 4 specify that for the skills set out in Schedule 2, if it does not meet all the applicable requirements, the uncompleted part meets the applicable requirements, then it can be exempted from DWDS. This is to reflect the present practice of the trade so that the general workers can finish the remaining parts of certain works. Can I ask a question on 5, bracket 5? You said fine at level 3. How much does it mean? Oh, $10,000. Please continue. Section 7. Exemption for small-scale construction work involving certain designated trade divisions. That covers 44 trade divisions, and the details are set out in Schedule 3 of the regulation. Similar to Section 6, subsections 1 and 2 specify that during the construction work involving trade divisions in Schedule 3, if they meet with the applicable requirements, then the relevant trade divisions can be exempt from DWDS. And for subsections 3 and 4, it is stipulated that the works does not meet all the applicable requirements when the construction work commences, then for the uncompleted part of the construction work meets all the applicable requirements, the relevant trade skills can be exempted from the DWDS.
Section 8, exemption for small value construction work. Subsections 1, 2, and 3 state that works not exceeding $100,000 can be exempted from the DWDS requirement. The relevant works should be independent and not contiguous to any other construction work. And the relevant works value is calculated on the basis of the total value of that particular work and all the contiguous works. And then subsections 4 and 5 state that the term construction contract and value are defined as such. Construction contract has the meaning given by Section 2, bracket 1 of the Construction Industry Council Ordinance. And value for any construction work that is carried out under construction contract, and it is the reasonable consideration. If it is too low, or if there is not such a consideration, then it should be calculated on the basis of the works to be expected on the open market for the carrying out of the construction work, and in considering the consideration, it can be based on the cost or value of materials, the cost or value of time, work, and labor involved, equipment used, overhead costs, and reasonable profit. This provision is related to Section 20 of the regulation. Chairman, I'd like to ask about the amount of $100,000. Will it be revised from time to time? Yes. Will you revise it because of inflation, for example? Thank you, Chairman. As I said, under the present ordinance, we do not specify a time frame for reviews. When I answered Mr. Yu Chong Yim, I already said that after the regulation comes into effect, we will keep the situation under review, and if necessary, we can propose an adjustment. In future, is CIC going to be the main platform for your liaison with the trade? Yes. Okay, part 3 is on the small-scale construction work and exemption. There are quite a number of provisions here, say what is meant by small scale and whether it is related to contiguous works, etc. And then the second part, exemption for emergency work, that is not so complicated. Any more views, members? Okay, let us carry on then. Part 4. Part 4. Exemption based on other enactments. Persons exempted under other enactments. This section applies if a person who is exempted under other ordinances, this person will also be exempted under the DWDS requirement. This is for the purpose of not affecting the operation of the other ordinances and also for the worker to continue to be able to undertake the works already exempted under those ordinances. And we are talking about 4 different trade works. One, escalator skill, lifts skill, and also gas safety worker. And this involves the lifts and escalator ordinance, CAP 668, gas safety ordinance, and also the gas contractor ordinance, and also the electricity ordinance. These are CAP 51D 618 and also 406, and the relevant regulations are already in the schedule. There are 4 schedules to the regulation listing the details of the exemption. Schedule 1, the 47 designated trade divisions are specified in covering emergency construction works and also small-scale construction works. And in formulating this schedule, we have given ample consideration to the safety of workers and the public. So this schedule does not include mechanical, electricity, lifts, and escalator, and gas installation works. Those have more implications on safety, and they are not included. Schedule 2. This has to do with small-scale construction works under Section 6. There are 13 items. In formulating the exemption, we have given detailed consideration to the operation of the trade and also the safety of the public and the industry. And there has also been a wide and broad consultation with the industry and other stakeholders. Should I stop here? Yes, please. Let us have some time to digest this. Schedule 2 defines the small-scale construction works. And there are technical provisions here, including depth, the area or distance, and the limits are set so that a certain project is regarded as a small works item. Yes, this has been formulated after full discussion with the industry. We have forged a consensus on all these. Any views, member? Please continue. Yes, I will talk about Schedule 3. This has to do with Section 7, small-scale construction works involving certain trade divisions. There are 44 items. In formulating such exemptions, we have again given detailed consideration to the operation of the trade and also safety of the public and workers. And we have also had broad consultation with the relevant stakeholders in the industry. and support has been given to all these proposals. Schedule 4. This has to do with Section 9. Exemption based on other enactments. And 4 trade divisions and 3 ordinances are involved. People mentioned in Schedule 4 will be exempted from the DWDS requirement, so that there will not be any impact on the exemption enactments under these ordinances, and so that workers can continue to undertake the works exempted by those ordinances. Yes, this echoes Part 4, Article 9. Correct. I believe members know this very well. We already looked at Article 9, and Schedule 4 is on the same thing. We have talked about lifts and escalators, since there are already ordinances regulating those. And the relevant exemptions follow the exemptions in those ordinances. I don't think members have any view on this. Okay. Chairman, we have completed the scrutiny of the regulation. Any questions, anything to raise? Legal advisor? Nothing. What about the English version? Any views? Why don't we look at the other one, the notice? Yes. Part 1, preliminary. Section 1, commencement. Subsections 1 and 2 stipulate that the notice will be enacted on the 1st of April 2017. And Schedule 1A has to do with cross-trade division, and it will come into effect 24 months after the DWDS requirement is enacted. And this tallies with the commencement date for Article 5. Since these 2 trade divisions are not covered by the existing ordinance, the stipulation of the commencement date aims at allowing these 2 trade division workers to be registered. As for the newly added trade, which is the cable jointer get cable, well, actually, it is a modular skill of an existing trade division cable jointer power. In order not to impact on the present operation, the cable jointer dead cable and also cable jointer power and other trade divisions will have the requirement of DWDS applied to them on the 1st of April 2017. At the initial stage of the stipulation of the new requirement, those unregistered workers who are cable jointer dead cable can work under the supervision of cable jointer power. The relevant arrangement has been the subject of consultation with the stakeholders in the industry who did not object. Any views? No views? Okay, you can carry on. Part 2. Amendments to Construction Workers Registration Ordinance. This part states that according to Provisions 3 and 4, there will be amendments made. Article 3, Schedule 1 amended designated trade divisions. This section amends Schedule 1 to add 3 new trade divisions, describing the relevant skills, the registration of full skilled and semi-skilled workers, and that they should be certificated. And we have included false ceiling installer This is under 13A, and then under 19A, adding of partition metal frame installer, and then under 35, cable jointer dead cable. Shall I continue? Yes, please. Article 4. It amends Schedule 1A, working across designated trade divisions. This article amends Schedule 1A in order to add in working across designated trade divisions, false ceiling installer, metal worker, and also metal worker. They can work across the trades, but they cannot supervise other workers in taking care of these works. But partition metal frame installer can undertake the work on their own, but they cannot supervise others. Part 3. Transitional provisions. Division 1. Prohibition and regulation. Article 5. Application of sections 3(2), 4, 4A, and 40A(1)(b) of the Ordinance. Construction work involving required skills of newly added trade division. As I said under Section 1 of the notice, and this has to do with metal worker and false ceiling installer, and they will be subject to the DWDS requirement, but only after 24 months of that implementation. The relevant requirements are in sections 3(2), 4, 4A, and 48(1)(b). Division 2. Registration, review, and appeal. Article 6. Registration of senior construction worker as registered skilled worker for newly designated trade division. This section introduces a one-off registration arrangement for 3 designated trade divisions. These have come into effect earlier on, and it is similar to the one that has terminated in September. And it states that starting from the 1st of April 2017, and that is the commencement date of this notice, if there is an aggregate of not less than 10 years of experience, these senior construction workers can make use of the registration in order to directly register with regard to the new designated trade divisions and become skilled workers.
And subsection 3(4) said that the application time frame is 18 months, and an application must be made before 1st of October 2018 so that the registrar can have 6 months to complete the registration work. Unless the registrar thinks it fair and reasonable to do so, the registrar should not handle applications made after that date. So this is a similar arrangement as existing practice. No problem? Okay, please continue. 7. Renewal of registration made under Section 6(1). The registrar may renew under Section 44 of the Ordinance a registration made under Section 6(1). And 8. Review of decision made under Section 6(1) or 4 and related appeal. This section stipulates that a person who is dissatisfied with the decision made by the registrar can, under Section 57(1) and 51(7)(b), make an appeal. So much for my presentation. Any questions? No question, members? The English version of the notice, legal advisor, any views? No. These are merely administrative arrangements in relation to the addition of trade divisions. And in the discussion of the principal legislation, we had long discussions on the exemptions. You have sought or forged a consensus with the trade. So I think the scrutiny went smoothly because there had been a lot of discussion within the trade already. Well, let's look at the legislative timetable. The expiry of scrutiny period, if it is going to be 11th of January 2017, well, there is no House committee before that date meeting, and the deadline for giving notice of amendment is 4th of January 2017. If we are to extend the scrutiny period, then that will fall on the 8th of February 2017. The report to the House committee will be made on the 20th of January 2017, and the deadline for giving notice of amendment to the subsidiary legislation is the 1st of February 2017. These are the proposed dates from the Secretariat. Taking into account that there is a meeting of the House Committee in the interim, there is sufficient time allowed for us to report to House Committee. I suggest that I move a motion at the Council meeting on the 11th of January 2017 for extending the scrutiny period to the 8th of February 2017. By doing that, the subcommittee can have more sufficient time to report to the House Committee. Any views? Administration, any view on this timetable? That should be okay. All right. After the meeting, we will make preparations to move this motion at the Council meeting on the extension of the scrutiny period. All right, we're done with the clause-by-clause scrutiny. That was quite simple. And I don't think there is a need to hold another meeting, right? Yes? Okay, at the Council meeting on the 11th of January, I will move a motion to apply for extension, and I don't think we need to hold further meetings after this one. AOB? No AOB meetings adjourned. Thank you.